This morning's docket, case number 110323, William Hoffner v. Kansas Department of Revenue.
Please the court, John Lindner for the appellant, and I would like to request 2 minutes for rebuttal.
2 minutes is granted.
I know how closely related the case that you just heard and this case are. However, as I looked at this and prepared for argument today, I see this, the Hoffner case, more from the standpoint of the application of the exclusionary rule to both civil, administrative matters and criminal matters. There is no other effective remedy. So if the rights that we are seeking to protect are going to be protected, the exclusionary rule must apply on both sides.
Do we have to, excuse me, counsel, do we have to overrule Martin, the Department of Revenue, to reach the result you want us to reach?
No.
And explain that to me.
That Martin is, of course, the case, the primary case that is cited by the folks on the other side of this, of my argument. I quote Martin, syllabus 6 of Martin in my petition for review: the implications of the Fourth Amendment and Section 15 of the Kansas Constitution Bill of Rights transcend the boundary of civil or administrative proceedings on the one hand and criminal proceedings on the other, because those provisions delineate rights that attach to individuals in either circumstance. So that is the core ruling and holding and philosophy of the Martin decision. Plus, the Martin decision was based upon another case, and probably not going to be able to find it. Seems to me like it was Turner, but it's in the petition for review, and that case does not have a hard and fast rule that the exclusionary rule does not apply. It specifically says that the exclusionary rule does not apply unless the actions of law enforcement were egregious. So I suppose it's the interpretation of egregious. Now, I don't think you have to change or overrule Martin, but you might have to tweak it. I would prefer that the egregious language not be there, because that's just another hurdle that we have to get over, and I believe an unnecessary hurdle. I think the
argument, I'm sorry to interrupt, but your argument's twofold. One, law enforcement's actions here were egregious, but number two, you should modify Martin and not make that a requirement.
Yes. Okay. That's fair. I don't want to cover plowed ground here, but the reasonable statutory or legislative interpretation on this search warrant argument, to me, is just not that complicated. I appreciate all the work that the panel, the Court of Appeals panel, went through in tracing the statutory provisions back, but to me, if you just look at the 8101D3 to start with, the legislature says that a law enforcement officer may obtain a blood test when the driver has refused to submit to a test if the driver was involved in an accident or collision involving or resulting in serious injury or death to any person.
Counsel, you're right. The Hoffner panel of the Court of Appeals went your way on that
Right.
issue.
Right.
Why were they wrong, however, to rule against your client with regard to the exclusionary rule?
Okay, because the exclusionary rule must apply, and that gets back to the provisions of the Martin decision that we have already that we addressed a moment ago. They applied a hard and fast rule. They announced that Martin says this. Martin says the exclusionary rule does not apply to civil and administrative proceedings, and that is not what Martin says. As we already said, Martin says that it doesn't apply unless the law enforcement officer's actions were egregious.
And so, just if I can grant you that premise for the purpose of this question, I'll grant you your recitation of the Martin rule. Why is it egregious in this circumstance when we have two Court of Appeals panels disagreeing with one another on the underlying issue? I mean, if two Court of Appeals panels can't agree on it, why would law enforcement be acting egregiously to agree with, to essentially have picked one of those two courses?
Well, I agree with what has been said about the implied consent law. And the right to refuse is granted by legislative grace. And when you go beyond that, what could be more egregious than having given the statutory implied consent advisories, having advised the person that they have the right to refuse, and this is what's going to happen to your license if you refuse, and so on and so forth based upon your record. And then when the person does refuse, well, it doesn't matter, we're going to get a search warrant and force it, and we're going to get it either way. What could be more egregious than taking that person's voluntary right to refuse away and using coercion to force their consent? To me, that's as egregious as it gets. Now, it's not physical, but...
How about taking away a person's right to travel down the road freely without being stopped by officers except for upon reasonable suspicion? Your freedom to travel is as important, I think, as your freedom to be against unreasonable searches and seizures. And Martin says that you can be unlawfully stopped as you're going down the highway lawfully, and nothing you can do about it in the administrative hearing.
That is why we've got to erase this fiction, this line between the two, and that's why we have got to apply it to the driver's license side, the administrative side.
I understand an argument to overturn or to modify Martin, but I understood you were making the alternative argument that this was egregious conduct, and I'm asking you to compare it with that in Martin and tell me why this was more egregious than what happened in Martin.
I believe what happened in Martin was egregious. Any ruling that says that a person can be stopped randomly without probable cause or reasonable suspicion, and there can be no remedy, no penalty to law enforcement, and no remedy for the driver, that is egregious.
So we're just back to the very first question I asked, which is we really do need to, if not fully overrule Martin, we really need to gut it. That's your argument.
Yes.
Okay.
Counsel?
As I was listening
Counsel?
to the...
I have
I'm
a
sorry?
question to follow up on that. At the time of Martin, I think the assessment was that that was the majority view. What Martin said, that the exclusionary rule would not apply in an administrative setting or a civil setting. Has that balance of authority out among our sister states changed since Martin was decided?
Well, not that I'm aware of, no.
Okay, thank you.
As I was listening to the arguments on the Webb case, this question about the no additional testing language, no additional testing shall take place. I wanted to comment on that. I don't know why that was taken out of the statute, but I think it's very significant what was left in. And that is particularly P, 101 P, that is just, to me, is just so clear. In such events, such test or tests may be made pursuant to search warrant. Why in the world would that be in there if it was not the intention that that's where search warrants apply and they don't apply elsewhere? But what came to my mind when the question was asked, why was that no additional testing language taken out? I don't know why it was, but possibly because of the development of the case law that allows a person to recant, to change their mind after they've refused and take the test. And that statutory language would be an impediment to that. In other words, if that's in the statute and a person says, no, I'm not going to take the test, and then changes their mind within a reasonable period of time, case law says the officer has to go ahead and give them the test, and that statutory provision would fly in the face of that. So that is one perhaps reasonable explanation for why they took that out, but it's so significant to me what they left in. And yes, I am asking that Martin be changed, overruled, tweaked, and I definitely think it is time, with all respect, to remove this fiction and to apply the exclusionary rule across the board to both proceedings. It's the only effective remedy there is.
Any more questions of council or any further presentation?
Just to clarify a factual matter, in this situation, your client consented to take a breath test only after the law enforcement officer or officers advised that they were going to get a warrant for a blood test.
That's correct.
And basically, he said, so you're going to get the test one way or the other. And that was what was the coercive circumstance, rather than driver's license or whatever. What coerced your client into agreeing to take the breath test was the threat of a warrant.
Yeah, the futility of it, you're going to get it either way. So,
Any more questions? Thank you, council.
thank you.
Would you agree with my last question that it's apparent from these circumstances that the coercion for, if there was coercion for the consent, was the advice that the officers were going to get a warrant for a blood test in any circumstance if he refused?
That's what Mr. Hefner's testimony was, Your Honor. But I believe that should also be peppered a little bit by his statement that he initially asked the officer for advice as to whether or not he should or should not take the test. The officer told him, I can't really give you that advice. And then he persists and goes ahead and says, no, I'm going to refuse then. And then the officer, in contrary to his own statement, gave him advice and said, if you don't take this, we're gonna go get a warrant.
Yeah, and that all makes sense to me, which also makes sense out of counsel's argument on the prior case. If the legislature really wanted to put the coercion in the implied consents, they would advise the driver that if you don't get it, the officers have the opportunity to get a warrant to take it anyway. Because that seems to be a pretty compelling circumstance for a driver. You can either consent or we're going to take it anyway.
Well, that's what this court has already held in Martin, and then basing that holding in Martin based on Hulsman. Hulsman, I think, is a 1986 case, if I recall. It's a pretty old case. And in that case, they talk about the coercion and that it does not run afoul of the Constitution. Before I move any further, I want to remind this court that 8-1001 subsection V says this is remedial law. In both these arguments, I have not yet heard the court mention the fact that this is remedial law and is supposed to be interpreted liberally to protect us from drunk drivers, not the other way around. So I wanted to make sure that the court has that in mind. Mr. Linder made a comment that there's a constitutional right of refusal. That's not correct. And as a matter of fact, we tell them in Implied Consent Advisory number 2, you have no constitutional right to consent or to refuse the test.
What is the basis of that, though, post-McNeely?
What's the basis of that?
How is that statement accurate,
How is it accurate?
post-McNeely?
Well, I think certainly you don't have any right under the implied consent. I mean, those would kind of clash with one another if you've impliedly consented to submitting to the test by virtue of the fact that you're operating a vehicle in Kansas. And then we turn around and tell you, you don't have to consent and you don't have to refuse. Aren't those just, do they offset one another, or are they so ambiguous that there's no meaning whatsoever left in the implied consent law? So that's a little confusing to me to even approach it from that perspective, but I see what your argument is. So I don't think McNeely makes any impact with regard to the advisories. They're advising them, you don't have a constitutional right to consent, you don't have a constitutional right to refuse. And then they go on and read them additional advisories that also temper those rights under McNeely. The right to independent testing, the right, all the other rights that we give them under the implied consent law.
But the sort of the point of that is if it was a significant change in the law that would destroy what had been what counsel earlier said was a statutory option to refuse that could not be overcome with a warrant, why wouldn't that significant change in the law be added to the implied consent advisories? It seems to me that if you're going to tell a driver that you have no constitutional right to refuse, you should also be saying, and what was previously a statutory option to refuse is no longer available.
Well, I guess, Justice Johnson, at what point do we stop telling people what the implied consent advisories are? I mean, we've got this very lengthy set of advisories that didn't come from the legislature initially. They came out of this court's admonishment to the legislature in Standish. And that's where those implied consent advisories came from.
I understand that, but we're talking now about statutory or legislative intent.
Okay.
Aren't we? And if it was the intent to make a really significant change in the law, then why wasn't that made clear in the advisories? And that would have shown this court very clearly what their intent was in removing those words.
So I guess your statement is that the legislative intent can be determined from the advisories that are given to the licensee as opposed to the statutory enactments? Because we're all presumed to know the law once it's enacted into the statute. And the legislature did in fact speak very clearly about this when they enacted in the 2010 supplement, which we all should be focusing on, the 2010 law as opposed to 2007, 2008. Both of these cases were after 2010 session law, so I just want to make that clear. In 2010, subsection G, the legislature says, if a person must be restrained to collect a sample pursuant to this section. Now, what does that tell you about no testing after refusal? What does that tell you about the legislative intent behind whether or not we want to do forced blood draws or not? If you have to restrain somebody, they obviously aren't consenting. If you have to restrain somebody to get a blood sample, you probably should have a warrant, and if you don't, then you've got to strictly follow the statute. And I agree that McNeely and several other cases have held that portion of the statute that says probable cause just based on the fact that you've been involved in an accident is not constitutional, or it looks like it's headed that direction anyway. But that's not the point.
But counsel, that subsection with respect to restraint, how does that tell us anything about what the legislature intended with regard to the circumstances in which law enforcement can get a search warrant? I mean, that doesn't tell us anything about what the legislature intended in terms of circumstances to get a warrant.
Well, the statute itself is wide open as to when an officer can get a warrant. The only limitation is when an officer can do a forced blood draw without a warrant. That's all that statute mentions. It doesn't say under no other circumstances no warrant can issue for someone arrested for DUI. It doesn't say there's no additional testing after the person refuses. So I think in large part the legislature amended the statute. I'd like to say that it was in response to AD and Weiler, but I can't make that claim because Weiler at least was decided in 2010, and the statute that they were operating under was the 2007 or 2008 statute. So it really doesn't have much application as far as this goes. And I have a difficult time tying legislative intent to specific case enactments, particularly because there's such a lag in when the case is actually decided and which statute we've looked at. Often they're 4 years old by the time the legislature actually gets around to acting. So whether or not those two are really correlate with one another, it's hard for me to make any comment on.
Often though, in interpreting statutes, we say that the mention of one thing means that they meant to exclude anything else. And here they've given us a very specific circumstance where you can get a warrant. Does
Right.
that then infer that you can't get a warrant otherwise?
No, I don't believe it does. Because it states very clearly that you can obtain a warrant, and it also states
Where does it say that? What language are you relying on for that?
In such an event, such a test or tests may be made pursuant to a search warrant. Okay? It doesn't say may only be made pursuant to a search warrant.
But it's
And look at
in such
subsection
event.
P.
It starts with in such event.
Okay.
And in such event is the preceding sentence, which is the accident that causes death or serious injury.
Correct. So it's giving specific circumstances where an officer can obtain a warrant, but it doesn't say anything about excluding all other circumstances from the ability to obtain a warrant.
So why is it there?
Why is it there? I think it's more directed. Actually, I looked at this language more directed towards codifying Schmerber, because Schmerber stands for the proposition that an officer has probable cause, he can obtain a blood draw without a warrant. The language is less than perfect, there's no question about that, but I don't think that it excludes the obtaining of a warrant under these circumstances. And then the additional statute, I believe you mentioned earlier, that nothing shall be construed to limit the admissibility of test results obtained to a warrant. You put all those things together and put them all in paramateria, and then you remedially look at that statute from the remedial law perspective and liberally construe it. I don't see how you could come to any other result. Otherwise, if you're going to strictly construe it and strictly construe that language to mean that only an officer can only use a warrant or obtain a warrant under those limited circumstances, then what's the point of having the other part of the statute where you can get a blood draw without the warrant? One of them doesn't make sense. There's no question about it. But I don't believe that the statute, as it's written, excludes that, and I think the legislative intent is clear that they intended to change the law, and they did in fact change the law by allowing for the restraint of an individual to forcibly take a blood draw, and they also removed the no testing after refusal language. So I think those are pretty good indicators of the intent of the legislature. Finally, with regard to the application of the exclusionary rule, Martin is very clear, and it's not just Martin. There are several other cases that this court has looked at to determine whether or not the exclusionary rule should or should not apply. It's my belief that the exclusionary rule is appropriately handled and dealt with in the case of in the context of the civil case. In this case, again, because of the remedial law aspect of it, I don't think that it should ever apply in these cases because the whole point of the law is to quickly remove drunk drivers from the road, not provide additional defenses to them. And so I don't think the remedial law aspect of Martin should be overturned or disturbed in any manner because the whole point of the implied consent law is to promote public health, safety, and welfare and protect us from drunk drivers.
Counsel, did you hear my question to your opposing counsel about the balance of this rule and other jurisdictions? I think Martin made the observation that it was following a majority position. Is that still the case, not the case? Can you tell us anything about that?
It would be just basically a guess just based on the cases that I've reviewed, and I think it's pretty much a wash across the board, honestly.
Any further presentation?
No, Your Honor.
Do we have any more questions? Thank you, counsel.
Thank you.
You reserve 2 minutes for rebuttal.
Thank you.
Counsel, you don't have to convince me about Martin. I think you're aware of the dissent that I authored in that case. But I'm wondering, in light of what Martin stands for, and that was in this, the remedial civil context, it was in talking about implied consent, the majority noted that it was designed to counteract the continuing slaughter on the highways of this state and those of this nation as a whole by alcohol and drug-impaired drivers. Your client ended up with a .215 alcohol concentration, 2.5 times the legal limit. How doesn't what happened here effectuate that purpose in the administrative context? Gets him off the road, his license is suspended. How do you respond to that?
Well, I don't want to be argumentative, even though that's the nature of our business.
Right.
But I think it deserves comment that Mr. Hoffner did not only wasn't involved in an accident.
No.
He didn't commit any traffic violations.
I understand that, but that's what Martin talks about, is that it doesn't matter. And if he's drunk, he was drunk, and a danger to not only himself but everyone else while he's on the road. What's wrong with that in the administrative context? He's not criminally sanctioned here. His license, as a result, is suspended.
He definitely would have a problem under the per se law. He would be acquitted under the under the impaired to the extent that you cannot safely operate a motor vehicle.
Right.
So, sure, that if you just look at that purpose of getting anyone with alcohol in their limit or in their system over a certain limit off the road, then that purpose is served. But at what cost to personal rights? I think that's the give and take. And I appreciate you bringing that up, because that's the point I realized that I needed to make when I'm asking the panel to work on Martin, to change Martin, to tweak Martin. I have to remember that I represent one client at a time, and today it's Mr. Hoffner, and Mr. Hoffner also has a very strong argument under Sloop and Schrader and all of the other cases that apply the exclusionary rule. They call it suppression, but they don't call it the exclusionary rule, they call it suppression for statutory violations. And this is a statutory violation that we're dealing with here. So you could certainly leave Martin alone and rule in Mr. Hoffner's favor. But so, whichever way you go, we appreciate, Mr. Hoffner appreciates your favorable consideration.
Counsel, the last sentence of Martin, I've been looking at that while we've been proceeding here. The last sentence of Martin talks about not applying the exclusionary rule because there really wouldn't be any additional deterrent effect other than from what you already get in the criminal setting by applying this in the administrative setting. Why is that wrong?
That is so wrong. I do a lot of work in this area, and with the exception of a couple of claustrophobic people that I can remember, every one of my driver clients would prefer to do a few days in jail and keep their license. The license is much more important.
But the issue in exclusionary rule type cases is the deterrent effect on law enforcement. So we really don't, the stakes that are involved for the defendant are, don't come into play when we're talking about the deterrent. And the whole purpose of the exclusionary rule is its deterrent effect.
Well, I guess when you're talking about the deterrent effect, you've got to assume that the individual cop cares about the case and cares about losing the case because he or she did something wrong. And it's what I just said. It's my experience that the police officers.
The police officer's not going to want to lose the conviction.
He's not going to want to. He's not
So
going to
they
want
already
to.
have a deterrent effect from that. So why does the administrative proceeding
Well, he.
add anything to that?
The individual law enforcement officer feels a great sense of pride, in my experience, in getting a driver that they feel like shouldn't be on the road off of the road and causing that problem, that person driver's license problems for some period of time. So if you make them do it right, then I guess there is the deterrence, because if they administratively they don't get the suspension because they did something wrong and the exclusionary rule applies. So I guess there's the deterrence. I think the police officers and the drivers really care more about the driver's license side and the driver's license penalty, and it is a penalty, than the criminal side.
Any more questions? See none. Thank you, counsel.
Thank you very much.
Thank you both for your arguments this morning. Court will take this matter under advisement. This time.